Alright. Contingent 1 is inherent to the station in the United States and more so under Congress and power to enact federal civil rights law under Section 5 of the 14th Amendment of the Gold Street in 2000. Striking out the civil rights remedy the following 9 U.S. Supreme Court Congress and power to enact federal civil rights remedy pursuant to the Congress Clause Section 5 of the 14th Amendment. The plan is not right here. Advantage 1 is domestic violence. Domestic violence is out of control in the United States now in 2006. Every day we're forming the country dollars on domestic violence. That's 14 women. The number of women has been murdered by murders greater than the number of soldiers killed in the war. Conservative estimates indicate 2 million women are already class about every year. Women are 10 times more likely to be victimized by men. Young women and African American women are disproportionately higher than social rate domestic violence. Rates are 5 times higher among families exposed to property and domestic violence is a critical contributor to patriarchy. Gulf War 2003. A major contribution to the modern families women who identify domestic violence can be by men against women as one of sexes have been part of violence, part of life, structure, and coalition, and subordination to the system is based on structural gender inequalities, political domestic violence grows out of the reinforcement phrasing section of dominance and female some domestic violence occurs on continuing along their bad state discrimination, including inequality, workplace deprivation, reproductive rights, and child care, acts of violence, approach to women vulnerable to violence, and then violence takes women more vulnerable to force disadvantage and patriarchy with NFL nuclear war reared in 93. We our patriarchal rules have had old patterns of the right, from new trade, Philadelphia, nuclear training, they would still living the only air, soul of water. We believe the war is necessary evil war compared to nature, consumption, human nature, will lock the life, paralyzed. The result of undetermined patriarchy will be a nuclear holocaust. The plan is that the United States Supreme Court should overrule U.S. wars by holding the federal source committee for gender-based violence are constitutional under correction power under Section 5 of the 14th Amendment. We assert the right to clarify all containing the advantage of constitutional assault sees all the Supreme Court overrule U.S. wars and until legitimate gender-based violence and sparking necessary changes in the legal system twice in 2001. If the United States wars with the court of violence to defend that, but the time to general often of which the challenge on parents when they defend voting for obviously the victim operates systematically and consistently to defend a certain person in the group and others defend individual women are also terrorized by the ability of the individual to terrorize and control women also institutional conclusions and law disclosure is particularly striking the definition of discrimination opportunities and analyses by the courts. The unwillingness of the courts to intervene certain legitimate domestic violence battle women are confined their safety and their opportunities are subject to litigation marks these consequences where our foundation powers improve the lives of poor lives and include the likelihood the courts will be responsible to battle women the courts to act to improve the conditions of real world lives when the world is bad you can get protection when it really does really mean there is only range of decades to come to legal system or abuse to recognize the national form that's a form of civil rights violation is experience of indication this time will start really does not merely illusory really symbolic it can gradually the right to women resource to make independent choices about their life and safety value and gender to leading culture with a tending change of public policy values and concerns additionally civil remedies more symbolic and encourage state reform and charge of Defender Davis in 2001. Biden saw this more power than civil legislation empowers the victim situation be countervailable criminal justice and laws regulating as a property law. She would otherwise be precluded from doing the file was really symbolic and there was a real symbolic purpose that was a part of the back referencing the state with federal government to forward to the issue that have a real effect on encouraging states to do a better job and had the effect of efficiently avoiding and observing some of the violence deterring some of the lawsuits in the first place and civil rights remedy is the most important step to reducing violence that she tried in 2000. The most significant the state of domestic violence and influence with the framework for gender equality in the state federal law reform respecting individual violence of the civil rights remedy following this will identify gender violence to harm a person behind gender and the equal important approach the identification of violence sexual abuse and rape and as gender affecting women's sexual freedom citizenship and qualities of fundamental women's equality of the corpus that women have generated the past 25 years the word legal working better and but plantation ways society conceptualizes violence as a whole shred of 2000. The redefinition of violence against women has been the federal protect family protect the right which supports women will be free that has considerable the political theoretical potential change the public conscience sexually and violence for the worst time there is a lot of these legal violence ever it equates the connection with the national evaluation involved with the private actually was intended with the veil of the relationship from the treatment of violence and restoration this into findings the link and linked it with equality when this going to be written such a form of discrimination if we do that why would we understand the form of discrimination is at the core of the act of all persons in the United States who have the right to be free or crime and movement of violence and gender violence could be a potential vehicle of power additionally federal civil rights remedy is the key and since the national legal social change against the advantage of plaintiffs to create gender motivated violence this is Gulf War 2000 once it taken more so nothing less than recognition that gender motivated violence not merely into new crime but it's all public share David Quality the language and civilized unique civil society there's an essence of violence so works reason that it transforms society how better we rape women there is with society's violence women how transform how we see women generally the creation of the federal rights women against some very large eventually follows the only sort of legal reading of any violence against women the only desirable alternative community law resources violence a lot of plaintiffs that they were seeing the state toward abuse better way considered and short tax limitations also overcame the inadequacy of the federal law and who are the plaintiffs who are taken under the code state law experience in favor of the plaintiffs exercise a federal protecting right the probability to get into a federal court was a major benefit for plaintiffs are still rather than criminal statute violence rights remedy was particularly valuable power to replacing control and engagement in their hands of avoiding obstacles gender violence among police and prosecutors violence rights was uniquely valuable weapon in fighting against motivated violence. Spanish 2 is hate crimes. Post 9/11 hate crimes have exploded in the U.S. building on the racist world we this season almost all Americans is to pray terrorists to Abel in 2005. Racism, white superiors usually threaten whatever unless a horrifying also anti-Arab and anti-Muslim sentiment in the United States Americans and then the vision conflict target these good people go through anti-balance and go as we go on the Gulf War 91 and other rights in the Middle East the misconception of American Muslims of the parallel alone for general this presumption of decades and for USA cause American Muslims the extreme violence go first and plunging into deep rooted racism driving the attack led them to racism violence against African American by huge streets in the Arab and American war Muslim and these crimes will balkanize society and gender an atmosphere of hate and fear evolve in 04. This argument trivializes area of violence and society hate crimes will polarized communities who made out fear of minority hate crimes, recognition problems with especially hate crime, enhancing criminal penalties with these particularly these act laws, the common to play comedy, solving adopting 46 states and help out the U.S. Supreme Court and tolerating hate crimes, genocide, puts human survival risk, business self in 93. Economic equality from the ordinary actual display of foreign effect, hate violence to a hate trace history, whether lynching, anti-Semitic, American Nazi ethnic cleansing, positive hate crime, violence, communities, and threatens their survival. And fortunately, Democrats are reviving their initiatives. They will reintroduce and pass federal hate crime legislation. This is the lady in 5 minutes. Six Democrats began pushing their return to power. James already came to party function in 2010 election. We was characterized as mandate for should be changed. Change that the do thing arms over the right social retain. Certain revive the long number of certain stall Democratic initiatives when the executive place control is the other advocating constitution Democrats expect to push strengthen federal hate crime laws and the status quo will strike down hate crime legislation that is the worst in the status quo. The plan to keep very awesome. Blah blah blah. It is apparent the local law enforcement 2011 constitutional requirements of the 14th and 13th Amendment abortion decision cannot be justified by the abortion chosen either 1 or 2. It can be justified under 14th Amendment since either destiny action absent the change of population. The Supreme Court and hate crime statute would not stand a chance, and we saw federal control symbolic confronts hate crimes and reduces polarization. Don't march on in 99. Despite the overarching sentiment against federalization, hate crimes often mean accommodation because it's necessary. Some federal involvement, not all hate crimes are inherently local. And nature of sophisticated crimes, so state lines be handled more effectively. Federal law, national hate groups are particularly more effectively prosecuted by the federal government. Prosecution and national level hate crimes to be justified, particularly because such crimes fracture communities and offend sensibilities to mention federal hate crimes would at the very least carry symbolic meaning, consistent with the notion of federal hate crime governments play a more role in protecting civil liberties and the rights of minorities. Next advantage is spending power. More than 40 the jurisprudence is used to prevent the conditioning of federal funds on compliance with state federal programs. This is law in 2006, or 2002 rather. Proponents of new federalism are either judicial administration of Congress authority in Section 5 of the Board of Administrative and federal power on spending power. The court of the federal spending programs are the supreme law of the court of the federal Medicare section does not secure this right because the state time choose to participate in the program in these whole industry. It's advanced the power of Congress to target federal funds, particular programs. The petition is so broad that parts radically within the new understanding the Constitution is difficult to fathom the impact and the power of the condition of federal funds is key critical enforcement of the Clean Air Act. This is McCarthy Amendment 7. Under the Clean Air Act, the EPA sets in national and air quality standards. The EPA administration certifies the state to fill this Section 179 nuclear authorizes withholding of certain federal highways for the school to be used for the EPA, whether or not it's actually used. The threat of imposing second division of prompt state action, the state official language at the legislative act, and pending the state action plan may argue that if they will act with the EPA, the EPA to cut state highway funds, and a strong Clean Air Act is key to freshwater protection. This is in the year 2005. The Clean Air Act can be seen as the Clean Water Act for the size of the importance of the clean water for the quality of our apparent atmosphere and obstructions in the water, groundwater, survey precipitations, chemical composition changes the becomes acid rain because the chemicals that your atmosphere increase the acidity of the precipitation, and the U.S. is key to freshwater aquatic biodiversity. The impact is extinction health in 2003. The United States is the World Center for Aquatic Biodiversity. One of the diversity of aquatic animals in the world can be found in our own backyard. Sustaining biodiversity is for health, survival, and quality of human life. We've been on aquatic life and animals that are ecological for our survival. Aquatic terrestrial biodiversity, source of food, medicine, energy, shelter, raw materials. We need every living organism important role to play. And many are indispensable aquatic life is important source of food, job, aquatic oxygen buffers against diseases, pests, predators, and protection against food diversion and global climate change. Observation 5 is overrules are coming in inevitable. Super controversial rules on PBA and the action area. They are in the pipeline. This is Coil 106. Robertson says the building efforts will be tested early in the most divisive issue for the High Court. Robertson when the Hammer is politically areas willing to change significantly, replacing O'Connor with the lead of the majority committee that was supposed to have affirmative action, replacing O'Connor with the lead of the Congress. The court's two key affirmative action cases, O'Connor was likely to vote to the law of school ruling Kennedy, one in the dissent, and the court will overrule desegregation and action cases. Now Buffalo News the court will overrule President the action case. The legal experts decided to be overturned because O'Connor was convinced to vote in 2003 because Robertson leader have been both the deeply sufficient of affirmative action. Additionally, PBA overturning Neville lead to makes the law of Buffalo News 6. Gonzalez and Carter will simply decide whether or not the reverse decision without rule bending lead to a motion proceed. There were constitutional legal scholars saying the court is not very likely to first overrule simply reason that O'Connor was the deciding vote. In this case, and in her place, she is the more conservative leader, and the court has overruled itself a total of 288 times. There's no impact to overruling. This is Costello in 2005. The Supreme Court has overruled 222 decisions. The general rule started cases not absolute. Court recognizing the occasions of correct what is perceived or decisions and adapting to circumstances are distinct constitutional decision that is called to a more manipulated and it is called malleable and incoherent, and the court overrules itself an extra 3 times. The term spring and Hansard 2 between 46 and 92. The Supreme Court overruled itself 150 times. It is prior to Senate average about 3 times. Overall 3 decisions. Overruled 3 decisions each time.
Okay. On your first advantage, you say that patriarchy makes nuclear war inevitable.
Yeah.
Why is that?
Written evidence talks about patriarchal assumptions, which were perhaps appropriate for like the Middle Ages when we fought each other with like horses and catapults and stuff like that, are no longer appropriate for the nuclear age because of the impact of things like global conflict.
Okay, so okay, cool. All right. And then your second advantage, you say that, okay, what's the story on the racism advantage? Sorry.
The argument is that in the status quo, hate crimes and hate is skyrocketing in the United States as a result of
September 11th and things like that. Our argument is that we need federal legislation to effectively police these hate crimes, or else they'll spiral out of control.
And you say your type of federal legislation is what's needed to...
When we read a piece of evidence in the case that the Democrats are going to reintroduce legislation that will pass, but it will be struck down absent the plan.
Okay.
Our argument, you have to change 14th Amendment jurisprudence.
Yeah, 14th Amendment jurisprudence has to be changed in order for that statute to survive. Our evidence indicates that absent that, I think our card uses the phrase "won't stand a chance."
Okay. And what type of legislation are they pushing through?
Our evidence talks about legislation that Kennedy is going to reintroduce. I don't think it goes to the level of naming the bill. It talks about a bill that Kennedy is going to reintroduce and that the Democrats will pass in the next Congress.
Okay, and then let's see. Okay, explain your federal spending, or your spending.
The argument is that in order to effectively condition federal funds to get the states to do things like implement the Clean Air Act, we need a change in 14th Amendment jurisprudence because the challenges to that won't be upheld in the status quo.
Okay, wait, so what, okay.
Yeah.
Let's see.
Congress should be able to withhold funding.
Yeah, Congress has to be able to, our evidence even says that they don't have to go so far as withholding because they can just threaten to withhold and that will trigger the states to get back in line with federal programs.
So why can't they do that right now?
Our evidence indicates that the current 14th Amendment jurisprudence makes that very problematic.
Why?
They can't do it
because it's not justified. Our evidence indicates that status quo 14th Amendment jurisprudence is going to preclude that. It says that, the card says that it's about deference on 14th Amendment and on larger questions. It talks about it's been extended, the way they've interpreted Section 5 has been extended to federal spending power and justifications based on that to enable these justifications. And they're getting ready to roll those back in the steps.
All right, how much time's left? Because I started my
10.
8 or 10.
All right, right on.